Hey everyone, Kirk here. You know, being a parent is tough enough as it is, but when your kid is navigating the education system with a disability, it can feel like you're fighting an uphill battle. Look, most of us want to believe that schools have our kids' best interests at heart, but let's be real, that's not always the reality. Sometimes you need someone in your corner who knows the law and can fight for your child's rights. That's where a disability rights attorney comes in. So, in this video, we're diving into the 7 warning signs that it might be time to call a disability rights attorney. Okay, first up, and this is a big one. The school refuses to evaluate your child for a 504 plan or an IEP. Federal law is pretty clear on this one. Schools are required to evaluate any student they suspect might have a disability. So if your child is struggling in school, if you've requested an evaluation and they're dragging their feet, that's a huge problem. It's not just a problem, it's a violation of your child's rights. Getting a 504 plan or an IEP is about getting them the support they need to access the same education as every other student, and that's where a disability rights attorney can really make a difference. They know the ins and outs of the law, specifically the Individuals with Disabilities Education Act, IDEA, and Section 504 of the Rehabilitation Act. They can help you navigate the system, file the necessary paperwork, and hold the school accountable. You don't have to fight this battle alone. Let's say your child already has a 504 plan or an IEP in place. You've been through the evaluations, the meetings, the paperwork, but having a plan on paper means nothing if the school isn't actually following it. Think of it this way. That 504 plan or IEP, that's not just a suggestion, it's a legal document. It outlines the accommodations and support your child is entitled to, by law. When the school ignores those accommodations, they are violating your child's legal rights. This is another situation where a disability rights attorney can be an invaluable resource. They can help you document those instances where the school is dropping the ball, and they can help you take action. Sometimes that means going back to the school and advocating for your child's rights. And in some cases, it might even mean filing a formal complaint or going through a due process hearing. Here's the thing about IEP and 504 meetings. They're supposed to be collaborative. You're supposed to be working together as a team with the school to come up with a plan that meets your child's unique needs. It shouldn't feel like an interrogation or a battle of wills, but sometimes it does. Sometimes these meetings can feel incredibly intimidating. You might have a room full of school staff, all speaking in jargon you don't understand, and it can feel like they're trying to rush you. If you ever feel pressured, if you ever feel like you're being railroaded into signing paperwork that you haven't had time to fully understand, that's a huge red flag. That's when you need to pump the brakes and say, hold on a second, I need to talk to someone who can help me understand my rights. And that's exactly what a disability rights attorney is for. They'll be your voice, your partner, and your protector in a system that can often feel overwhelming. This next one is so important. When schools resort to disciplining students for behaviors that are directly related to their disability, it can have long-lasting negative effects on the child. It's like punishing someone for something they can't control, and it's just plain wrong. Imagine being reprimanded for something that is a part of who you are. It's not just unfair, it's damaging to the child's self-esteem and development. Both Section 504 and IDEA have very specific guidelines about disciplining students with disabilities. These laws are designed to protect students and ensure they receive a fair and appropriate education. Before a school can suspend or expel a student with a disability for behavior that might be linked to their disability, they have to conduct something called a Manifestation Determination Review, or MDR. This review is crucial in understanding the root cause of the behavior. An MDR is a meeting to figure out if the behavior in question was caused by the student's disability. It involves teachers, parents, and other professionals who know the student well. If the behavior was indeed caused by the disability, the school can't just dole out the same punishment they would to a student without a disability. Instead, they need to consider alternative strategies that address the behavior in a supportive way. But schools don't always follow these rules. Sometimes they might overlook the guidelines or misinterpret them, leading to unjust consequences for the student. If your child is facing disciplinary action and you suspect that their disability might be a factor, you need to contact a disability rights attorney immediately. They can provide the necessary legal support and guidance. They can intervene, make sure the school follows the correct procedures, and protect your child from unfair and illegal discipline. Remember, knowing your rights and advocating for your child is essential in these situations. One of the most disheartening things I hear from parents is when they feel like the school is blaming them or their child for the challenges they're facing. This feeling of being blamed can be incredibly isolating and frustrating, especially when parents are already doing their best to support their children. Instead of offering support and working together to find solutions, the school throws up roadblocks and points fingers. This adversarial approach can make it seem like the school is more interested in protecting itself than in helping the child succeed. Maybe the meetings feel more like interrogations, with staff questioning your parenting choices or the validity of your child's diagnosis. This can be incredibly disheartening and can erode the trust that is essential for a productive partnership between parents and the school. Let me be crystal clear, it is not your job as a parent to diagnose your child's disability or to single-handedly solve all their challenges. Your primary role is to support and advocate for your child, ensuring they have the resources and opportunities they need to thrive. Your role is to advocate for your child, to be their voice, and to work collaboratively with the school to ensure they receive the support they need. This means being an active participant in meetings, asking questions, and pushing for the services and accommodations your child is entitled to. If the school is creating a hostile environment, that's a major red flag. A school should be a place of support and understanding, not a battleground where parents feel attacked or dismissed. A disability rights attorney can help shift the focus back where it belongs, on the school's responsibility to provide support, not judgment. They can offer legal advice and representation to ensure your child's rights are protected. They can help you navigate these difficult conversations and ensure that the school is held accountable for creating a safe and supportive learning environment. With the right support, you can turn these challenges into opportunities for growth and improvement for your child. One of the fundamental principles of special education law is the concept of least restrictive environment, or LRE. This principle is designed to ensure that students with disabilities have the opportunity to be educated alongside their non-disabled peers to the greatest extent that is appropriate for them. It's a fancy way of saying that students with disabilities should be educated alongside their non-disabled peers to the maximum extent appropriate. This means that whenever possible, they should be in the same classrooms, participating in the same activities, and learning the same material. The goal is to keep kids with disabilities integrated in the general education classroom as much as possible. This integration helps foster a sense of belonging and community, which is crucial for their social and emotional development. But what's not okay is when schools use segregation or isolation as a default, when they unnecessarily remove students with disabilities from the general education setting without justification. This can happen for a variety of reasons, but it often boils down to a lack of resources or understanding. Maybe your child is being placed in a separate classroom for the majority of the day, even though they could be successful with some support in the general education classroom. This kind of placement can limit their opportunities to interact with their peers and participate in the broader school community. Maybe they're being excluded from field trips or extracurricular activities, or they're not allowed to participate in recess or lunch with their peers. These exclusions can make them feel isolated and different from their classmates. This kind of isolation can be incredibly damaging to a child's social and emotional development. It can lead to feelings of loneliness, low self-esteem, and even depression. If you suspect that your child is being unnecessarily segregated or excluded, you need to speak up. Start by talking to your child's teacher or the school administration to understand why these decisions are being made. A disability rights attorney can help you understand your child's rights under the LRE principle. They can provide guidance on how to advocate for your child and ensure that their educational needs are being met in the most inclusive setting possible. They can advocate for a more inclusive and appropriate educational setting. Remember, every child deserves the chance to learn and grow in an environment that supports their unique needs and abilities. Navigating the special education system can feel like a full-time job, especially when you're facing roadblocks and resistance. It's emotionally draining, it's time-consuming, and it can be incredibly overwhelming. So here's my final red flag. If you're feeling lost, if you're feeling overwhelmed, if you have that nagging feeling in your gut that something's not right, but you don't know what to do next, that's a sign you need to reach out for help. You don't have to navigate this alone. A skilled disability rights attorney can be your guide, your advocate, and your source of support. They can help you understand your rights, explain the legal jargon in plain English, and develop a strategy to advocate for your child's needs. They can handle communication with the school, gather evidence, and represent you in meetings and hearings. Remember, you are your child's strongest advocate, but you don't have to be their only advocate. Look, I know it can be daunting to even think about hiring an attorney, but here's the thing. When it comes to your child's education and their future, you can't afford to wait. The earlier you involve a disability rights attorney, the better your chances of protecting your child's rights and securing the support they need to thrive. What might seem like a small problem now, a minor disagreement with the school, can quickly escalate into a major violation if it's not addressed early on. At Covenant of Courage, we're dedicated to connecting families like yours with trusted legal partners who specialize in fighting for the rights of students with disabilities. So, if you're seeing any of the warning signs we've talked about today, please don't hesitate to reach out. Empower yourself, defend your child, and take courageous action.